Thanks very much, and thanks to everyone for joining us today. I'm a partner in Mayor Brown's Washington, D.C. office and a member of our Supreme Court and Appellate Practice Group. I'm joined today by three of my colleagues, Dan Himmelfarb, Gary Isaac, and Andy Tauber. Dan is a partner in the Supreme Court and Appellate Practice as well, and a co-leader of the D.C. office litigation practice. He's filed more than 200 merits and petition stage briefs in the Supreme Court and scores of briefs and oral arguments in other federal and state appellate courts around the country. Gary is a counsel in our Chicago office, also in the litigation group. He advises and advocates on behalf of clients in product liability and mass tort litigation at both the trial and appellate level regarding important strategic issues, including the personal jurisdiction issues that we'll be discussing today. Andy Tauber is a partner in the D.C. office as well, and also in our appellate group. He's briefed and argued a wide variety of cases for clients on issues as diverse as federal jurisdiction, in product liability cases, asbestos cases, and also has handled attorney-client privilege and antitrust liability and First Amendment issues for our clients. Before we begin, a few housekeeping announcements. As we go along, we hope that you'll ask questions by using the Q&A panel, which, if you look at your screen, is located on the lower right-hand corner. We'll try to answer questions as we go along or at the end, and if we're unable to get to your questions, we'll certainly get back to you after the webinar is over. Second, regarding the all-important CLE credit, we will provide during the course of the webinar a slide with the alphanumeric code that you need. In order to receive the CLE credit, you have to record the code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program, and we'll emphasize that again when we get to the magical code. Finally, one caveat: the views that we will all express today are our own and should not be attributed to our firm or our clients. With that, let's get started. So first, we thought we would just briefly cover why is this relevant, a little refresher on personal jurisdiction for those of you who may not remember back to first-year civil procedure, and why this issue has come to the fore now. So just a reminder about personal jurisdiction. Personal jurisdiction is the test for when a court has authority over the defendant, obviously a critical element that has to be present in any litigation. And the Supreme Court has said for decades that due process limits a state's power to assert personal jurisdiction over defendant because of the need for fairness to defendants, but also that federalism limitations, the need for states to stay in their lanes and not intrude on the regulatory authority of their sister states, is also an important consideration in setting the standards for personal jurisdiction. There are two types of personal jurisdiction that the Supreme Court has specified: general jurisdiction and specific jurisdiction. So starting with general jurisdiction, that's the broadest form. That's the situation where the court can hear claims unrelated to the defendant's activities in the forum state. And you see there a quote from the Supreme Court's recent decision in Daimler explaining how general jurisdiction works. It's a situation where the corporation's continuous operations within the state are so substantial to permit the forum state to hear suits on causes of actions arising from activities that have nothing to do with the in-state activities. So a very broad form of jurisdiction. The second form of jurisdiction is specific jurisdiction. That's claims related. The forum court can exercise personal jurisdiction because the claim is related to the forum state. And the basic standard you see there from Daimler is the suit arises out of or relates to the defendant's contacts with the forum. So these concepts, personal jurisdiction, general jurisdiction, specific jurisdiction, they've all been around for a while. So why the focus on them now? And the focus on them now really is a result of the Supreme Court's decision in the Daimler case just about 3 years ago that significantly changed some of what had been pretty long-standing rules about jurisdiction. Prior to Daimler, many state courts had held that general jurisdiction was available, so jurisdiction over any claim, whether related to the forum or not, was available as long as the defendant corporation had, quote, continuous and systematic contacts with the forum state. And for many states, like California or New York or other large states, that was a test that the state courts and the federal courts applying state principles had found to be met. And therefore, general jurisdiction was the rule and was broadly available in not every state, but in a large number of states. Daimler said, hold on, that's not the right test for general jurisdiction. Daimler said the contacts for general jurisdiction have to be, as you see, so continuous and systematic as to render the corporation essentially at home in the forum state. And the court went on to say that test will be satisfied for the corporation's state of incorporation and for its state of principal place of business, but only in extremely rare cases for any other state. And the example that the court gave shows you how rare it was anticipating. It was an example of a situation where during World War II, a corporation that ostensibly was located in the Philippines had moved to a U.S. state temporarily because of the war, and the court in that case had held that general jurisdiction was available there. So pretty clear that in the post-Daimler era, at least as the Supreme Court envisioned it, general jurisdiction only available in these two locations, which for some companies obviously may be the same state, and almost nowhere else. So, and in fact, I should say the Supreme Court said that in its opinion. It said specific jurisdiction should be probably will be the standard that governs most lawsuits. General jurisdiction will be more of a rarity. So what are the consequences of Daimler, and why should defendants care about this development in the law? So the consequences are, when suing outside those two potential home states, plaintiffs are going to have to establish specific jurisdiction, and the result of that has been much more focus in the lower courts on what the standards are for specific jurisdiction, something that had been less important, at least in the cases where general jurisdiction was pretty freely available. But the critical thing for defendants and for litigation strategy is the Daimler decision gives defendants new tools to avoid plaintiff-friendly magnet jurisdictions. As almost everyone on the call, I'm sure, knows, the practice of defense counsel had been, let's find a friendly court, either because it's where the defense counsel happens to be, or it's where friendly juries are often picked, or where the law or judges are friendly to the plaintiff's side of the case, and just bring cases there using the formerly broad rules of general jurisdiction. Now, there are tools to fight back against that phenomenon, to force claims that are into the defendant's home state, where they can always be brought, but at least to prevent the practice of aggregation of large numbers of claims in these magnet states, even claims that have nothing to do with those forums, because that was, A, convenient for defense counsel, but also a very effective way to put leverage on defendants by making them face very large aggregate liability in a pretty hostile forum. So now, using the tools that we're going to talk about, and in the post-Daimler world, those gambits by plaintiff's lawyers are susceptible to the defense of, you don't have personal jurisdiction over the defendant in those magnet jurisdictions, therefore your case has to be dismissed. As a result of that, plaintiffs have begun to fight back. They've attempted to reintroduce general jurisdiction in some guises that we'll talk about, the consent by registration theory, or the theory that as long as there are a couple of cases that actually are properly subject to specific jurisdiction, plaintiff's going to lump a lot of other cases into the same forum on the theory that, you know, there's a sort of friendliness in crowds, even though those other cases couldn't be brought in the forum if they were the only cases being brought. And then the other argument is, or the other playing field where this battle is being fought, is on the standards for specific jurisdiction. If the plaintiff has to rely on specific jurisdiction, how will those rules be framed? Will, as some courts are doing, specific jurisdiction be broadened so that in some senses it may resemble general jurisdiction in terms of the kinds of contacts that can be relied on that have either no or only a very tangential relationship to the lawsuit. So the bottom line is Daimler gave defendants an important and powerful way to push back against the use of magnet jurisdictions and the use of aggregation. Plaintiffs, seeing that pushback from defendants, are pushing back again, and our goal today is to really give you a sense of how these tools are being used, and in particular, what the best arguments are for defendants who want to use the opening that Daimler has created to provide a way out of magnet jurisdiction litigation. And with that, turn to Dan to talk about the first issue on the plate, the use of this registered agent consent theory to try and essentially circumvent Daimler's limits on general jurisdiction.
Thanks, Andy. An out-of-state corporation that wants to do business in a foreign state, a sister state, generally has to register to do business there, pay a fee, and agree to the appointment of a registered agent to accept service of process in the event that the out-of-state company is sued there. One of the tactics that the plaintiff's bar has employed since Daimler was decided was to argue that there is general jurisdiction in the state where they want to sue and where they wouldn't otherwise be able to sue on the theory that a company, the defending company is registered to do business there, and a company that registers to do business in the state thereby consents to general jurisdiction there. Now, this theory has both state law and federal law aspects. The state law aspect is that there has to be a state statute that has been interpreted to mean that registration is tantamount to consent. Most state statutes that require registration say nothing about general jurisdiction, much less consent on the face of the statute. So to the extent that there are state statutes that permit this theory, it's generally by virtue of judicial interpretation. Once you have a state statute that's been so interpreted, you then get to the second question, which is whether the Federal Due Process Clause permits this, and more specifically, whether Daimler permits this. So what arguments do plaintiffs make? Generally, what you see them make in defending against the motion to dismiss when they're asserting this theory of personal jurisdiction is, first, there is an old Supreme Court case, now nearly a century old, called Pennsylvania Fire. It's a Justice Holmes decision. Like many of his decisions, it's quite succinct, somewhat cryptic and opaque. But for many years, and still in some courts today, it's been interpreted to mean that this theory is consistent with due process. Plaintiffs also rely on some lower court decisions, which more recently, say in the latter half of the 20th century, have endorsed this theory or have said that it's consistent with due process. As you'll see on the slide, these are post-International Shoe decisions. International Shoe is a mid-20th century Supreme Court decision that sort of shifted the doctrinal focus of personal jurisdiction from one where the focus was on territory and presence in the state to one that was based on the familiar term minimum contacts. And then you have the argument that Daimler doesn't affect this theory. Daimler was not a case about consent. Plaintiffs argue consent is an entirely separate basis for personal jurisdiction. It can exist when there wouldn't otherwise be general or specific jurisdiction. And Daimler didn't purport to be saying anything about consent-based theories of jurisdiction. What arguments do plaintiffs make, can they make in response to these kinds of arguments? And again, just to sort of frame the issue, there are both state law and federal law aspects to this. A plaintiff has to win on both. And the arguments I'm going to be talking about, which are generally constitutional arguments, obviously go to the second aspect of this, which is the federal law aspect, but they can also be relevant to the state law aspect. Because if you have a question whether the state law in question in fact allows this theory, and you're arguing that as a matter, you as a defendant are arguing that as a matter of state law, it shouldn't, one of the principles you can rely upon is this doctrine that's sometimes known as constitutional avoidance. The basic idea is that if you've got two possible interpretations of a state statute, one of which would raise constitutional concerns and the other wouldn't, you should prefer the one that wouldn't. So if the state statute is interpreted to permit a consent-based theory of jurisdiction merely by virtue of registration, and if that would create constitutional problems under Daimler, the argument goes, you should not interpret the state statute that way, and you don't even have to get to the federal question. So what are these constitutional arguments? The first one is that the theory of registration equaling consent is just fundamentally at odds with Daimler, and it's at odds with Daimler on multiple levels. First, as Andy mentioned at the outset, Daimler held, it squarely held, that doing business in a state is not enough as a constitutional matter to permit the exercise of general jurisdiction. That was once thought to be the case in many courts, probably most. It's not after Daimler. So if doing business isn't enough, registering to do business necessarily isn't enough, because you don't even have to do business to be registered. It's a lesser form of activity within the state. What else can you say about Daimler? Under Daimler, there's general jurisdiction ordinarily in at most two states, where the company is incorporated and where it's headquartered. Under this theory of consent-based jurisdiction following from registration, at least for big companies, there could and often is be general jurisdiction in all 50 states, since many big companies are registered in all 50 states. And the third point, which is really related to the first two, is less of a sort of doctrinal point, more a common sense point, but I think it's no less compelling for that reason. The basic idea is that Daimler was viewed by most people, correctly I think, as a landmark decision on the issue of general jurisdiction. If this theory that by registering to do business you consent to jurisdiction were correct, then Daimler wouldn't be a landmark decision. It would be a futile gesture, because you could circumvent it through this device. And the quote I have up on the screen comes from a Second Circuit decision which rejected this theory, and I'll be talking a little bit more about that in a couple of minutes. But the formulation they use, which I think is a nice one, is that if the theory were correct, Daimler would be robbed of meaning by a backdoor thief. Now, it is true this is a consent-based theory, so I think any argument against the theory would have to say something about consent. And I think what the argument would be is whatever else consent means in other contexts, you can't have consent to jurisdiction in this context simply by registering to do business. Insurance Company of Ireland is a Supreme Court case which catalogs the types of situations in which you can consent as a defendant to personal jurisdiction, lists about a half dozen of them, and I think what you can say about them is, first of all, while it lists many, it does not list registration. And the types of consent it does list really have nothing to do or nothing in common with registration to do business. The kinds of things this case is contemplating is a consent in a contract, a forum selection clause, a stipulation to jurisdiction in litigation, appearing generally in the case where that has any meaning, failing to raise the defense, invoking the court's processes, for example, by filing a counterclaim. These are all things that are truly voluntary, knowing involuntary acts. Defendant knows what it's doing and is accepting jurisdiction. That's quite different from the idea that because some state court interprets a registration statute to mean that a defendant registering to do business in a state consents to jurisdiction there, that is somehow consent. The unconstitutional conditions doctrine is also something that can and I think should be invoked here. It's got a number of nuances which I won't be getting into today, but the basic idea is that when a government confers a privilege on someone, ordinarily anyway, it can't make the waiver of a constitutional right a condition of obtaining that privilege. And here, the idea is that by conferring the privilege to do business in the state is saying you have to waive your right not to be sued there, and we know that this is, you would otherwise have this constitutional right under Daimler. Ultimately, this consent theory is really just, I think the argument would go, is really just wordplay. Everybody would have to agree that if you said after Daimler, you're subject to jurisdiction if you register to do business in the state, that wouldn't survive Daimler. It can't be that if you substitute the words consents to jurisdiction for subject to jurisdiction, that somehow magically changes the analysis. And frankly, at the end of the day, that's really what the theory comes down to. And then the last point is that Pennsylvania Fire is a very old decision, was decided at a time when personal jurisdiction was thought about in very different ways. The Supreme Court has said a number of times in more recent cases, including in Daimler, that cases deciding during that era, that territorially based jurisdiction era, should not be given much weight today. And in fact, in the Lockheed Martin case, which I've mentioned and which I'll say a little bit more about in a minute or two, the court said just that. So these are the cases, the principal appellate decisions that have come down on this issue since Daimler. The first and the third, Brown versus Lockheed Martin and Genuine Parts versus CPEC, reject the theory but do so as a matter of state law. Brown was a Second Circuit case that was interpreting Connecticut law. CPEC, a Delaware case interpreting Delaware law that in fact overruled a very old Delaware decision pre-Daimler that had interpreted the Delaware registration statute to mean that it carries consent to general jurisdiction with it. The types of analysis you saw in those two cases were the statute doesn't say this on its face. In Brown versus Lockheed Martin, the court said that there was no definitive interpretation of the statute by the Connecticut courts, and then in both cases you had this sort of constitutional avoidance rationale, which is if we were to interpret the statute this way, it would be constitutionally problematic given Daimler, so we're not going to. I should say that those are the main appellate decisions. The federal and state trial courts have been split on this since Daimler. My sense is that the trend has been in a defense direction, at least since these decisions have come down. The case in the middle punted on this issue is a Federal Circuit case which found that there was specific jurisdiction, so it didn't have to reach the question, but there was a concurrence which would have reached the constitutional question and would have found that this is perfectly consistent with Daimler. But as far as I'm aware, you've just got that one appellate judge in that case who's reached the constitutional question and ruled in the plaintiff's favor. I should say, in the interest of full disclosure, Mayor Brown was involved in all three of these cases. We represented Lockheed Martin. In the first case, we filed amicus briefs for the Chamber of Commerce, as we've done in many other cases in the other two. Okay, let me just finish up on this quickly. Is this headed towards the Supreme Court? And if it is and gets there, what's likely to happen? I guess my sense of it is that it's not going to get there anytime soon, because as we've seen from the appellate decisions, a lot of these cases get decided on state law ground. I would think that for the Supreme Court to get interested in this, you'd have to have a conflict among federal appellate courts or state courts of last resort on the constitutional issue, the federal constitutional issue, which would mean at least one of those courts would have to find that this is fine as a matter of state law and it's fine as a matter of federal constitutional law, and then you get another court or more courts saying it might be fine as a matter of state law, but it's not fine as a matter of federal constitutional law. Then you'll have the split on the constitutional issue. We're not close to that point yet. If we get to that point and it gets to the court, what's likely to happen? Well, this is not the kind of case where you're likely to have a 5-4 split, as you get in many cases and in many business cases. Daimler was an 8-1 decision. Goodyear, on which it relied heavily, was a 9-0 decision. Both were written by Justice Ginsburg. This is not a case that's the type of case that's likely to divide along Democratic-Republican lines. So I would have thought, even before last Tuesday, that the plaintiff's likelihood of success in a case like this, if it reaches Supreme Court, would be low. I think in light of what happened on Tuesday, the chances are even lower, but that obviously remains to be seen. And as I've said, I don't think we're close to Supreme Court review on that issue yet. Let me turn this over now to Andy Tauber, who's going to talk about Daimler's implications for mass and class actions.
Thank you, Dan. So Daimler restricts the availability of general personal jurisdiction for plaintiffs, so they try to avoid it in a variety of ways. Dan just discussed one of their tactics. I'm going to talk about a different tactic that plaintiffs have been using to get their cases into plaintiff-friendly forums, notwithstanding Daimler's restrictions on that practice under the theory of general jurisdiction. So plaintiffs are trying to use an expansive concept of specific personal jurisdiction to get their cases into plaintiff-friendly forums. And they do this, they have two variants of this tactic. I'll discuss primarily the first. The second is a more extreme version of the first. The principal tactic that we've seen plaintiffs doing this, and we've seen it in California, we've seen it in Missouri and other jurisdictions that are perceived to be plaintiff-friendly by the plaintiff's bar, is to use joinder as a way of getting cases into plaintiff-friendly jurisdictions that shouldn't be there and don't belong there and can't be there under Daimler. So the idea is that plaintiffs will join many plaintiffs who have no reason to be in the forum state with at least one plaintiff who can legitimately obtain specific personal jurisdiction over the defendant. So they bring suit on behalf of multiple plaintiffs, one of whom can legitimately assert specific personal jurisdiction over the defendant because the conduct giving rise to that individual's claim does arise in the forum state. And then they use the state's joinder rules to join the remaining plaintiffs and argue that joinder with respect to them is proper because the conduct giving rise to their claims is at a very high level of abstraction. That's the key to their tactic. The same as the in-state conduct giving rise to the claim asserted by the plaintiff who can obtain specific personal jurisdiction legitimately over the defendant. And then plaintiffs say, well, because one plaintiff indisputably can obtain personal jurisdiction over the defendant, and the other plaintiffs are, in their view at least, properly joined, all plaintiffs can obtain personal jurisdiction over the defendant. I and Gary, who you'll hear from shortly, have been litigating this in Missouri, and what we see there is they find a plaintiff who was supposedly injured in that plaintiff-friendly forum state after a manufacturer's local sales representative allegedly induced the plaintiff's surgeon to use the defendant manufacturer's medical device in a purportedly dangerous manner. And then they join other individuals who are allegedly injured in other, less plaintiff-friendly states after their surgeons were allegedly induced to use the same device in a similar manner by sales representatives in those other states. And then they contend that joinder is proper because the conduct at issue, inducement by the defendant manufacturer sales representatives, is supposedly the same with respect to each plaintiff, notwithstanding the fact that the different sales representatives in different states made different representations at different times to different surgeons treating different patients with different conditions. So that's their tactic. They use joinder to bring these claims into a plaintiff-friendly jurisdiction. Now, a variant on this, which I've at least seen in theory, I personally haven't litigated any such cases, is a more extreme variant on this, which is they will bring suit on behalf of multiple plaintiffs, none of whom can legitimately assert specific personal jurisdiction over the defendant based on conduct occurring in the forum state, but nonetheless assert that there is, in fact, specific personal jurisdiction over that defendant because, in theory, the conduct giving rise to plaintiff's claims was nationwide conduct that occurred in every state, including the forum state. marketing tactics or employment practices and say, because it occurred in every state, including this forum state, we can come here. So those are the plaintiff's tactics to get around Daimler using mass and class actions. There are responses that we have, that we, the defendants, have to these tactics. I want to talk about 3 of them. The first response is sort of geared at the second variant that I was discussing, but also certainly applies to the first as well, which is to argue that a defendant's nationwide practices cannot be used to create specific jurisdiction in each state. Basically, our argument here is that using nationwide practices to assert specific jurisdiction in each state would be contrary both to the Supreme Court's general personal jurisdiction jurisprudence as well as its specific personal jurisdiction jurisprudence. So as to the first, we would argue that attempts to use nationwide practices to establish specific jurisdiction in each state in which a corporation operating nationwide operates would eviscerate Daimler. Just as Dan was talking about with respect to the consent theory, so too here, if nationwide practices were sufficient to establish personal jurisdiction, the national corporations would, in effect, be subject to general jurisdiction in each state. But that is clearly contrary to Daimler, under which corporations are subject to general jurisdiction in only 2 states, namely the states of incorporation and the state in which they have their principal place of business. And insofar as Daimler rejected the proposition that continuous and systematic contacts with the forum state are sufficient to establish general jurisdiction, this theory is plainly contrary to that holding. And the second thing, I'm remembering that the plaintiffs are using a tactic of asserting not general personal jurisdiction, but what they claim to be specific personal jurisdiction. The second argument we make in response to this is to challenge the specific jurisdictional argument that plaintiffs are making. Basing specific jurisdiction on nationwide practices that did not cause a particular individual plaintiff to be injured in the forum state is, this defense argument goes, contrary to the Supreme Court's specific personal jurisdiction jurisprudence as articulated in International Shoe, Helicopteros, Goodyear, and Walden, each of which hold in varying formulations, but at bottom, that specific jurisdiction exists only when a claim arises from a defendant's activity in the forum state. I think Andy Pincus will be coming back online shortly. We'll be talking about this in somewhat more detail. There is actually a cert petition currently pending out of California, Bristol-Myers Squibb versus Superior Court, number 16466, which arises from a California Supreme Court decision where the court, in a 4-3 decision, found that specific personal jurisdiction existed over claims brought by plaintiffs who did not ingest the drug in question in the state of California because, so the California Supreme Court held in that split decision, because their claims were based on the same allegedly defective product as sold in California and based on the same allegedly wrongful marketing campaign as allegedly occurred in California. The cert petition has been filed as well as amicus briefs in support. We're waiting. Andy's signaling to me that evidently he has written one of the amicus briefs in support of the cert petition, so I'm sure he'll have somewhat more to say on this. I suspect that we will see it probably in January sometime on the cert petition. Andy might have some more details there. So anyway, that's one of our responses, to argue that asserting that nationwide practices create specific jurisdiction in each state is simply wrong, inconsistent with both general personal jurisdiction jurisprudence as well as specific personal jurisdiction jurisprudence. And the second defendant's response tactic, or excuse me, the second argument that defendants have available to them in response to the plaintiff's tactic is to fight the jurisdiction by joinder maneuver that plaintiffs are employing. The defendants should and can argue that personal jurisdiction must be separately established as to each claim asserted by each plaintiff. There is no such thing as supplemental specific personal jurisdiction. In the words of the Fifth Circuit, there's, quote, "There is no such thing as supplemental specific personal jurisdiction. If separate claims are pled, specific personal jurisdiction must independently exist for each claim, and the existence of personal jurisdiction for one claim will not provide the basis for another. We have that law from the Fifth Circuit, from the First Circuit, from the Second Circuit, from the Third Circuit, from the Ninth Circuit, as well as lower court decisions in the last year or so out of Minnesota, Illinois, New Jersey, and elsewhere. And not only is it the case that personal jurisdiction is claim-specific, defendants have a very good argument that specific personal jurisdiction is plaintiff-specific. And there are numerous cases standing for the proposition that a court, quote, may not exercise personal jurisdiction over some plaintiffs solely because it has personal jurisdiction over others in the same case. That comes from an Eastern District of Michigan decision, but we have others from across the country standing for that same proposition. So the idea is that you resist the joinder theory by arguing that each individual plaintiff must establish specific personal jurisdiction as to each claim asserted, which is something they can't do under specific jurisdiction properly understood. And particularly in the context of class actions, again, a topic that Andy knows quite a bit about, the Rules Enabling Act, so 28 U.S.C. Section 2072 sub B, provides that the rules of civil procedure, including those permitting class actions, cannot abridge, enlarge, or modify any substantive right, a statute that was alluded to both in the Walmart decision on class actions as well as Tyson. So that, again, is an argument that defendants have available to them, that they do not lose any rights in class actions, and therefore, just as an individual plaintiff would have to establish specific personal jurisdiction as to their claim, generally, so too in class and mass actions. And then finally, the third tactic or the third response that defendants have in response to the plaintiff's joinder tactics is to fight joinder or class certification if it's a class action on ground, just the normal grounds that one would in general. So to challenge plaintiff's attempts to abstract and generalize the conduct at issue and instead emphasize the individualized issue, to emphasize that there were different actors in different circumstances acting at different times in response to different conduct with different results. And so you defeat joinder or class certification as a way of getting out from the plaintiff-friendly jurisdiction. I should note that just last week, the Missouri Intermediate Appellate Court, which is a bad court for defendants, issued just a horrific decision on joinder, the case Barron versus Abbott Labs, held that joinder based on nationwide marketing is proper. I presume that will be going up to the Missouri Supreme Court. We'll see what they do. Not terribly optimistic there. And then finally, the last and standard tactic, as in all cases, is all else failing, to move to sever and dismiss the claims asserted by non-resident plaintiffs on forum non-convenience grounds. With that, I will now turn things back to Andy Pincus.
Thanks, Andy. Just one comment on the class action aspect of what Andy was talking about. I think for years, for as long as I've been practicing, most defendants have figured that if they were sued in a class action, nationwide class action in particular somewhere, and there was jurisdiction, personal jurisdiction with respect to the named plaintiffs, they were sort of stuck, and that was the end of the story. And I think Daimler really opens the door in a significant way, because of the arguments that Andy was just talking about, for the first time to something that I think is almost certainly sort of theoretically correct, although it might take a little while to convince lower courts of it, which is that, in fact, nationwide class actions can only be asserted against defendants in forums where the defendant is subject to general jurisdiction, or for some particular reason, because there's only one factory or something, that all of the class's claims could be brought in that state. But I think there's a powerful new argument that could really revolutionize class action filing and move class actions away from basically being a tool that plaintiffs had almost total control over just by picking named plaintiffs to something where they don't. And the principal tool for fighting back on this is the Rules Enabling Act that Andy mentioned, and the very, very good language in last year's Tyson Food decision where the court basically specifically said, citing the Rules Enabling Act, that the class action device can't be used to take away a defense that the defendant would have in an individual action. And since it's quite clear that in an individual action you could require each person to prove personal jurisdiction, there's no reason why, just by agglomerating everybody into a class action, that goes away. As I say, probably that's a long-term project because it would really significantly change class action litigation, but I think it's something that defendants should be seriously considering as they look at their litigation options going forward. But now to turn to the next question, which is we've talked about the devices for trying to avoid or reopen the door to general jurisdiction. What if the plaintiff realizes they can't do that? What's the alternative? And the alternative in many states and in many post-Daimler cases has been, well, why don't we try and broaden the standards for specific jurisdiction so that the kinds of contacts that can be considered are so broad that although we're labeling it specific jurisdiction, we're really finding a form of general jurisdiction because there's no real relationship between the contacts and the claims. So again, first starting with a little bit of background, the Supreme Court actually addressed specific jurisdiction also in 2014 in a case called Walden against Fiore, and reaffirmed that it's the defendant's suit-related conduct that has to create a substantial connection with the forum state. So two important things about that test: it's suit-related conduct and the need for a connection with the forum state as opposed to the plaintiffs. That's the critical elements that the court is looking at. So just to drill down on the suit-related nature of the contacts, I think it's important to recognize in pushing back against these efforts to broaden the universe of contacts away from things that are directly suit-related, to know just how firm the Supreme Court has been in focusing on suit-relatedness as the test. So in Daimler itself, you can see a very good quote. It's about whether the in-state activities give rise to the liability being sued on and whether the suit relates to that in-state activities. And then in a recent earlier case, Goodyear, again, you can see it's all about the connection between the forum and the contacts with the forum and the suit. And there's a very good reason for this. What the court has said, going back to the International Shoe decision that Dan mentioned, which really set the rules in this whole area, the whole rationale of specific jurisdiction is the reason the forum can assert judicial jurisdiction over the defendant is because there's the defendant's connection with the forum is such to enable the forum to assert some sort of regulatory authority over the defendant with respect to the conduct that gave rise to the suit. That's the sort of due process and federalism underpinnings of this whole theory. And therefore, having the contacts that permit jurisdiction be related to the suit is critical for that notion of regulatory jurisdiction to make sense. And you see on the screen a couple of additional quotes that make clear that that's really what's going on here. So let's turn with that sort of basic background in mind to these efforts that seem to be underway, pushed by plaintiffs and accepted by some lower courts, although we should say by no means all. And one of the things that's important to realize is, although we're talking here about instances and arguments that plaintiffs have been advancing, as Dan and Andy mentioned, there is a lot of good authority out there for defendants on all of the topics that we're addressing. But the BMS case that Andy mentioned is one example of this phenomenon where the court said sales of products in the state, because it was a sort of a nationwide sales program, was sufficient to provide specific jurisdiction, quote unquote, over these claims that had nothing to do with any product that was sold in the state. So one effort to expand by pointing to similar activity with respect to in-state plaintiffs allows personal jurisdiction over the out-of-state plaintiffs. Another theory is efforts to promote the company's services or products in the state, or even to sell them, that have nothing to do with the claims, but are relied on by the courts to say, well, see, there really is a connection between this company and the forum, even though the connection has nothing to do with what's the matters in suit. We're going to rely on that connection as a permissible contact to support specific jurisdiction. Again, totally overturning the notion that there has to be a connection between the subject of the suit and the contact, and just saying as long as the defendant has some contact, we'll leverage that into permitting the subject of the suit. That's a claim in a case called TVS TECA that is now the subject of a cert petition before the Supreme Court arising out of the Supreme Court of Texas. And we'll see whether that case was granted. Like BMS, that is a case in which we've recently filed cert petition, amicus brief in support of the cert petition on behalf of the U.S. Chamber of Commerce and a number of other business entities. And then the third phenomenon that's worth mentioning is really a long-standing problem in terms of expansive jurisdiction that's gotten worse and is getting more focused as a result of the fallout of Daimler. In 1987, in a case called Asahi, the Supreme Court dealt with a claim involving personal jurisdiction over product manufacturers and the so-called stream of commerce theory. What were the circumstances in which a state could assert personal jurisdiction, usually in a product liability action, although not always, in the situation in which the manufacturer put the product into the stream of commerce with the knowledge that because it was a nationwide market, that product either would or might end up in the forum state. And at that point, supporters of broad personal jurisdiction, including the plaintiffs' bar, were arguing putting something into the stream of commerce was enough as long as it was foreseeable that the product would end up in the forum state. And 4 justices in 1987 agreed with that theory, said yes, that's enough. But 4 other justices said no, more is required. And as you can see, their notion was there had to be some conduct purposefully directed by the defendant to the forum state. Maybe it was designing it specifically for that market. Maybe it was advertising something that showed some purposeful conduct directed to the forum state. That disagreement has festered for the past 30 years. The Supreme Court tried to take a bite of the issue again in the McIntyre case in 2011. This time, a plurality of justices agreed with the more is required view from Asahi, but not enough to get a majority, and other justices specifically declined to address the issue. So this trend remains festering. I think if we step back and look at what has been said about the kinds of contacts that are required to support specific jurisdiction, it's hard to imagine that merely putting something into the stream of commerce with the idea that it's possible it would get somewhere is sufficient to support the kind of regulatory jurisdiction that the court has been focused on, especially in cases like Walden and Goodyear and recently. But we don't know, and the stream of commerce theory has been used by plaintiffs who are worried about other specific jurisdiction tests to say, well, even if we can't meet the test that's required in terms of the claim relating to the contacts based on the language that was on the prior slide, this stream of commerce idea is a sort of a separate notion that gets us around the need to prove specific jurisdiction under the current test for that. So this issue is the subject of a cert petition also coming to the Supreme Court, before the Supreme Court now, from the State Supreme Court of Washington, and we'll see whether the court is willing to bite off this issue and resolve it, given that this circumvention of the careful rules that the court has laid down in other specific jurisdiction contexts is a real increasing problem for defendants. So with that, let me turn things over to Gary.
Thanks, Andy. I'm going to deal with a couple of practical considerations. Quickly, we may run a few minutes over. Our apologies. Practical considerations, the need to preserve the issue in the trial court, and also dealing with putative jurisdictional discovery. The next slide. Actually, the slide after that. So first, talking about preservation of the issue. Ordinarily, a challenge to personal jurisdiction has to be raised at the outset of the case, but federal court rules may vary or differ from state court rules, and rules will vary across the states as to precisely when and how the personal jurisdiction objection has to be raised in order to preserve it. Many of us went to law school at a time when we learned about special versus general appearances. It's no longer necessary generally to file a special appearance to contest personal jurisdiction. And under the federal rules, lack of personal jurisdiction can be raised either in an answer as an affirmative defense or in a motion to dismiss. But if a defendant does file a motion to dismiss and raises other issues, it must raise the personal jurisdiction issue in the motion to dismiss as well in order to preserve it. Next slide. Some states permit the defendant to raise the issue in an answer. Others require a motion to dismiss, and there are all kinds of variants. In some states, filing a pro forma motion to dismiss without even filing a supporting memorandum or ever noticing up the motion for a decision by the judge is enough. In other states, you have to actually not just file a motion to dismiss, but promptly present the motion for hearing and a decision by the court in order to preserve it. Really, the bottom line here is that it's necessary to, when served with a complaint, to quickly analyze whether or not there is a personal jurisdiction argument, and if so, to analyze how you need to act in order to preserve it. And it's imperative, and this is, I think, really the main point I would stress here, that it's imperative to check the local rules, to look at how the local rules have been interpreted, to ensure that if you have a viable defense of lack of personal jurisdiction, that it's not waived inadvertently, because there are all kinds of permutations across the states about how exactly you need to raise the issue. And so it's imperative that you right at the beginning look at the rules to see what you need to do in order to preserve the issue. Even if personal jurisdiction is raised properly, i.e. in a motion to dismiss or in an answer, it could subsequently be waived in many states by participating in the case in particular ways, by participating in merits discovery, for example. And so this is another area where it's really critical to look at the law in the jurisdiction, in the forum where you're litigating, to see what the rules are about not only how to raise the issue in the first instance, but whether particular conduct in the litigation might be deemed a waiver. So in some states, Andy talked earlier about our litigation in Missouri, and Missouri is a state where once you've raised the issue, you can pretty much participate in litigation across the board. But in other states, even if you preserve the issue initially, you can be deemed to waive personal jurisdiction by serving affirmative discovery on the merits, or even responding to discovery on the merits without first trying to get a decision on personal jurisdiction. And in many places, if you have raised a personal jurisdiction defense but then seek affirmative relief from the court, like move for summary judgment on the merits, you're going to be deemed to have waived the personal jurisdiction defense. Doing ministerial things like asking for more time to file an answer or otherwise plead, that's probably not going to be a problem. Responding to jurisdictional discovery should not be a problem. Next slide. There is authority for the proposition that removing a case from state court to federal court before answering is not a waiver of personal jurisdiction. And again, ordinarily, if you raise lack of personal jurisdiction in a motion to dismiss, it's okay to also raise in the same motion to dismiss in the alternative substantive grounds for dismissal for failure to state a claim. But if you are going to move to dismiss on other grounds, you must raise lack of personal jurisdiction in the motion, in the same motion, in order to preserve it. So, again, the critical point here is that the preservation rules are going to vary from state to state in federal courts, depending upon what circuit you are, what district you're in. So it's really critical to check the local rules right at the outset of the case before taking any action in the case to make sure that you know what the rules are for raising and preserving the personal jurisdiction issue. Next slide. Now I'm going to turn briefly to another kind of logistical, practical issue that we have seen in cases. Even if there is a valid personal jurisdiction defense, plaintiffs often respond by trying to serve the defendant with burdensome, putative personal jurisdiction discovery, going back 50 years to make the defendant answer interrogatories and serve documents relating to all of its activity in the state, going back to 1950. We've actually seen this in cases, and it's certainly the case, unfortunately, that some courts, especially in plaintiff-friendly jurisdictions, often allow the plaintiffs considerable latitude in pursuing, putative personal jurisdiction discovery. But we've also seen, particularly following Daimler, and given the high standard for general jurisdiction that's articulated in Daimler, that other courts have required plaintiffs to at least plead a prima facie case for personal jurisdiction before permitting any discovery, or they've certainly been open to objections to really narrowly limit discovery to what might be relevant under Daimler. Next slide, please. So the starting point for responding to putative jurisdictional discovery, especially where there is a general jurisdiction issue, is Daimler itself. In Daimler, the court said that personal jurisdiction should ordinarily be resolved expeditiously at the outset of litigation, and it commented that, quote, "It is hard to see why much in the way of discovery would be needed to determine where a corporation is at home," unquote. And so that's a good place to start any opposition to broad discovery requests from the plaintiffs, with the Supreme Court's recognition that the standard for general jurisdiction is onerous. Ordinarily, it's just where the defendant corporation is incorporated or has its principal place of business, and therefore discovery as to other business activity in other states should be very, very limited if it's permitted at all. Plaintiffs often try to blur the line between general and specific jurisdiction, and it's important in objecting because, again, a lot of judges have the notion in mind, it's a pre-Daimler notion, as long as the defendant was doing business in the state, it's subject to jurisdiction, to really make the plaintiff defend discovery requests either as that could plausibly lead to information that would satisfy Daimler, which is hard to do, or that it would plausibly satisfy specific jurisdiction, which means they have to show that their own claims arise out of or relate to the context in the state. So it's important to make the plaintiffs remind the court of what those two standards are and push the plaintiffs to show how they could possibly gain information with their broad discovery requests that would permit the court to exercise either specific or general jurisdiction. And there have been many cases post-Daimler in which courts have declined to allow any discovery at all, any jurisdictional discovery, and granted motions to dismiss without allowing discovery because it was obvious that the discovery would not lead to information that would satisfy Daimler. Next slide. Another important consideration, an important objection, is that under Daimler, the issue of whether a defendant is subject to general jurisdiction is measured at the time suit is filed. So a fishing expedition going back to 50 years is not relevant to whether the defendant is at home in the forum state at the time suit was filed. Some courts have broadened it a bit to say that you can go to a period in advance of when suit was filed, a reasonable period, but there's a very strong argument that discovery requests that try to go back decades or 10 years are not permitted. And where specific jurisdiction is at issue, again, it's often possible to object to particular requests on overbreadth or burdensomeness grounds where the plaintiff can't show that his or her claims actually arise out of or relate to the business activity, the defendant's contacts with the state. And one final point that I want to make is oftentimes it's a reasonable and appropriate and prudent course to oppose personal jurisdiction discovery, allowing the plaintiff any personal jurisdiction discovery, but sometimes it may be better as a strategic matter actually to respond to jurisdictional discovery in a limited way rather than trying to avoid it altogether. And there are two reasons why this might be useful. One, answering some interrogatories or providing some documents may make your client look more reasonable to the court and may make the court look more favorably on your objections to the other discovery. And really, second, we have found it's frequently helpful to to answer some interrogatories because you give self-serving interrogatory answers that will actually support the motion and make the objections to other discovery requests look stronger. So, for example, if your client doesn't have any office in the forum state or doesn't own or lease any real property in the forum state or doesn't have any employees in the forum state, those are good facts to get out, and you want to affirmatively use them. So even if you don't answer any other discovery, if you want to just inject those facts into your discovery response so you'll be able to use them in support of the motion to dismiss or in support of your objections to other discovery, that could be a very worthwhile, prudent thing to do. And now I'll turn it back over to Andy.
We just want to highlight that a number of the issues that we've discussed today, we've mentioned it during the discussion, but just to sum up, a number of the issues we've discussed today, as you can see, are before the Supreme Court in cert petitions. We've worked on amicus briefs for the Chamber of Commerce in the Bristol-Myers, TVS TECA, and we will be filing one in the Phillips case. There are some other petitions pending as well, but I think there's a reasonable chance that with all of these petitions before the court and the general ferment in the lower courts on this issue, there's a chance that we'll see at least some activity in the Supreme Court this term trying to resolve some of them. So with that, thanks very much for joining us. We hope the information was useful. Any questions, please email them to prucker, P-R-U-C-K-E-R, @mayorbrown.com, and we'll answer them. And I know some people submitted some questions on the screen that we were unable to get to, and we will get back to you on those. And with that, thanks again for joining us, and have a good day.